I'm your host, Kevin Bemmel, and we're here every Monday morning at 10 a.m. Pacific Time, 1 p.m. Eastern Time, with an hour in for Central and Mountain. And we talk about all things related to your personal estate planning, as well as for professionals who are either already involved in estate planning and trust and estate administration, or who are looking to get into that field, perhaps as an adjunct to their existing business, or maybe you're new to the business world and you're looking for a career. I can tell you that there's a big need for fiduciaries, people who can administrate estates and trusts here in California. And in fact, in California, it's a licensed profession. So, and I can also tell you that our license fees went up this year. They more than doubled. I think they're about $1,400 now for a 2-year license. But lot of business opportunity. And so something well worth considering if you're casting around for a career change. So today we're going to talk about ethical considerations in trust administration, or in estate administration, I should say. And this is important whether you're an individual who has been appointed as a trustee or a co-trustee or an executor, or the court has appointed you as an administrator for an estate to handle a probate, or whether like me you do it professionally. So let's jump right into this. There we go. It's still taking me just a little bit to remember how all the new system works here. So here we go. Ethical considerations in estate and trust administration. So there we go. So as is the case with all of the Way to Wow shows, they're all based on the 3 pillars of attainment. And we generally deal in the finances realm of the pursuits pillar, but we also get involved in relationships and sometimes even the self pillar. All right, so there are 5 duties, if you will, 5 ethical duties that every administrator, whether the person is a trustee, an executor, like I said, a court-appointed administrator, there are 5 basic duties that ethical duties that need to be fulfilled, and you see them here on the screen: loyalty, care, impartiality, confidentiality, and accountability. And we're going to talk about all 5 of those, and also then we'll wrap up talking about some best practices in terms of how to fulfill those ethical duties. Okay, so let's start out with the first one, which is loyalty. Okay, so in the settlement of any estate, there is going to be at least one beneficiary. Now, if it's a will, the will presumably identifies the beneficiaries. If it's a trust, the trust, again, will identify the beneficiary or beneficiaries. Okay. Now, if a person has died intestate, they have no will, they have no trust. So then part of your job may be to find out who are the beneficiaries of the estate. Okay. And it typically it would be if there's a surviving spouse or there are surviving children. If it's not in those categories, you may need to look to parents, siblings. Beyond that, you could look to grandparents, to grandchildren, to nieces, nephews, aunts, uncles. Each state has its laws about descent and distribution. I remember in my real estate training days, we used to say a 5th cousin is too distant to qualify as a beneficiary under the laws of descent and distribution, at least here in California. Nonetheless, if the person has not identified, if the decedent has not identified the beneficiaries. So that's going to be your first job. And it is to the beneficiaries that you owe your duty of loyalty. So when all is said and done, okay, and in administrating an estate, it is for the benefit of the beneficiaries. Okay, so you need to be loyal to their interests. Now, we're going to talk about some aspects of that as we go through this presentation. Okay, but right now we're just talking about your general duty of loyalty. So that duty of loyalty supersedes certainly the duty to yourself, but it also supersedes your duty to any third party, whether it's a lawyer, whether it's a spouse of a beneficiary or a child of a beneficiary. Okay, so that is your primary duty of loyalty. And also, it means avoiding conflicts of interest. So you could be both a beneficiary and a trustee. Okay. Now that puts you in a conflict of interest. Okay. Now, presumably, we'll talk about the case of a trust. The grantor or the trustor, the person who set up the trust, recognized that you were going to have that conflict of interest. Okay. So you don't need to resign as trustee, but you will have to be very careful about how you manage conflicts of interest, or that particular conflict of interest anyway, to make sure that you're not favoring yourself over the other beneficiary or beneficiaries. Okay. Now, if let's take a more straightforward situation. You're not a beneficiary, but you are a trustee. Okay, so you in that case you need to avoid conflicts of interest. So let's say, for example, the estate owns a piece of property and you would like to buy that property. Okay, well, now you're in a situation where you're both supposed to be doing the best for the beneficiaries, but at the same time you want to get the best deal on the property for yourself. So that's a conflict of interest. Probably not a position that you want to put yourself in. Okay, now there could be extenuating circumstances. Maybe no one wants to buy the property for whatever reason. And so, you're prepared to be kind of a buyer of last resort, I should say, not result, the buyer of last resort. So in that case, how that conflict of interest is managed will be very careful. And even though you have, it's a trust in this example, and so the sale of the property wouldn't in most cases be subject to court confirmation, you may decide to apply to the court to confirm the sale in order to make sure that any conflicts of interest are cleared legally before you proceed. Okay, so that's loyalty. Next is care. Okay, so with respect to the beneficiaries, you owe the duty of care. And what that means is you have a reasonable duty to avoid things like undue risk. Okay, now when we say reasonable, we're setting a standard of what would a typical person knowledgeable about the duties that you've been assigned, what would that person do? How would that person handle matters? Okay, so it doesn't mean that if something goes wrong, you have necessarily breached your duty of care. Okay, you may have acted perfectly reasonably, and yet, maybe the market collapsed. Okay, something outside of your control happened that diminished the value of the estate. That does not mean you haven't been reasonable or that you haven't fulfilled your duty of care. It just means that You were subject to the vagaries of the market just like everybody else. Okay, now part of the duty of care requires you to invest prudently. Okay, so you don't want to take on undue risk. So let's say, for example, that the beneficiary is the spouse of the decedent, and let's say that she's elderly. So the level of risk in investments that she could tolerate, given her age, let's say that she's living off of the income from the trust, okay, and that's maybe that and Social Security are her sole sources of income. So to engage in risky investments would not be appropriate for this particular beneficiary. On the other hand, maybe the beneficiaries are all children, okay, and they don't need current income from the trust, okay, and so and in fact they're not entitled to any distributions until maybe they reach the age of majority, 18 or 21, whatever may be specified in the trust documents. And so really what matters is capital appreciation. So in that case, what would be the prudent investments for the trust in order to achieve capital appreciation, so that at the time they do start taking distributions, there'll be a maximum amount of assets there for them to do that. Okay, so investing prudently is viewed from the standpoint of why is the trust set up, or let's switch from a trust. Let's say it's an estate, okay, so it's being settled maybe by probate. So it may be that that there's a big cash position in the estate, okay, and the money is going to be distributed fairly quickly. So then it wouldn't make sense to invest it in a long-term security necessarily. Maybe it's going to beneficiaries who have current income needs or current expense needs. Okay, so again, when we talk about investing prudently, we mean in relation to the situation of the beneficiaries, which means you're going to need to know that. Okay, care also means avoiding waste. So, for example, let's say the estate has some real estate in it. Okay, so that property or properties need to be properly maintained. Okay, so they perhaps let's just say it's a house, okay, and let's say there's nobody living there, okay, so the house needs to be properly maintained despite it being vacant. Okay, so the lawn needs to be mowed, the roof needs to be checked to make sure it doesn't leak. The pipes need to be checked to make sure that the house doesn't get flooded, if there something like that. Okay, so you'll need to make sure you're avoiding waste, something that can be fairly common when there's real estate, although it could certainly apply to other types of investments as well. Maybe there's a cattle ranch, okay, and there's a horse farm, and the animals need to be properly cared for, otherwise they'll die. Okay, so as the fiduciary, as the trustee or the administrator, you'll need to make sure that those things are handled. Okay, next, impartiality. So we were talking about beneficiaries earlier, and I said we're gonna get into this in more depth. So here's the first part of this. So when you have multiple beneficiaries, you need to act ethically, you need to act impartially, that is, not favor one over another. And that may be difficult at times. There may be one beneficiary who treats you very respectfully, and is very easy to deal with, and there could be another that who's a jerk and is insulting and all of those kind of things, and yet it doesn't matter. They still both have to be treated, if assuming they're equal beneficiaries, so then they both have to be treated equally. Okay. Now, if you're a beneficiary along with being a trustee, okay, and there's other beneficiaries, you cannot favor yourself. Okay, now, by the way, just because you're trustee doesn't mean you have to disfavor yourself. All the beneficiaries need to be treated, I don't want to say the same, because that gets to the second point there, according to the terms of the instrument, that whether it's a will or a trust or whatever. So the terms of the instrument creating the estate may not require that the beneficiaries be treated equally. One of them may be entitled to a larger share, or one of them may, in fact, maybe there's a child who's disabled in some way, even if the child is an adult. And so the decedent has given that child preference in terms of resources from the estate being used to care for that child. So then that has to be attended to by the trustee or by the administrator or whatever. Okay. But in general, what needs to happen, assuming beneficiaries are sharing equally in an estate, so then they all need to be treated impartially. They all needed to be treated with equal decency, etc. No favoring of any individual. Okay, next, confidentiality. So confidentiality essentially means that you can only make disclosures to those who are entitled to know about the business of the estate. Okay, now that may be just the beneficiaries. Okay, now, by the way, there could be debtors of the estate, or people who claim to be debtors of the estate, who are clamoring for information. They may not be entitled to know. It depends on the nature of the debts, okay, whether those debts actually survive the death of the decedent. Okay, so the best thing to do is to be very careful about to whom you disclose information. And if you're not sure whether someone is entitled to know or not, as you'll see when we get to best practices, make sure that you clarify your duty before you act. Okay, so that doesn't mean that you have to be a jerk. Let's say a beneficiary, or let's say the spouse of a beneficiary wants to know some information. So the spouse, if the spouse is not a beneficiary, him or herself, okay, then generally speaking, they probably are not entitled to know. However, okay, the spouse may have a power of attorney to act on behalf of the beneficiary spouse. Okay, in that case, then they may well be entitled to know, because they're acting in place of or instead of the actual beneficiary, and they're handling things. Okay, the beneficiary may have a business manager, or someone who handles their financial affairs. Okay, and they're under contract to do that. So then maybe that individual or that organization who's in that position, they may be entitled to know. Again, if you're unsure, we're going to talk about this in best practices, before you act, make sure that you're on solid footing. Okay, now, generally speaking, there are certain parties who are authorized by law to obtain information. So if the court is seeking information, most likely they're doing so legally. Now, that doesn't mean that simply because you get information from a court that you disclose information. So for example, a trust, generally speaking, is not under court jurisdiction when you're administrating it. Okay, so you could get a court order saying that you have to disclose some information, but that doesn't mean that you can't fight the court order if it appears to you and your advisors that the court was wrong in issuing that order. Okay, so when I say authorized by law, again, what I'm conveying is the idea that make sure that what you're being told is the law is in fact the law. Okay, so if there's litigation going on, it can happen that someone will get a court order, and that court order could be improper. Okay, and it needs to be appealed or it needs to be challenged. Okay, so again, think, double check if you're not sure before taking any action, and especially before disclosing any kind of confidential information. Okay, next, accountability. So when we talk about accountability, again, we're going to be talking about the beneficiaries. You are accountable to the beneficiaries. Okay, so number one, you need to keep accurate records, okay? Written records in most cases, okay? So if there are brokerage accounts, so presumably the brokerage is issuing monthly statements or at least quarterly statements, something like that. So those need to be reviewed in a timely fashion, okay? If let's say there's some real estate and there's a property management company that's handling the management of the property, maybe it's an apartment building or a retail building, something like that. Okay, so that property management company should be required to provide periodic accountings, typically once a month, okay, of how much income was collected, what were the expenses, okay, who was paid what, how much, and sometimes it might even require knowing why that person. Now, if it's a utility bill, then it's because the utilities were used. But when it comes to maintenance expenses, okay, why were there maintenance expenses? By the way, a good question also may be, why were there not maintenance expenses? I mean, is the property in such good shape that nothing went wrong with it that month? That could be a good question. Now, maybe the property is very new, it's in great shape, and okay, so then no big deal. Okay, but on the other hand, if the property is kind of older and it's got some problems, so then why is it that there's no maintenance expense? Okay, and there may be a good reason. It may be that there's some ongoing repairs and the bills haven't come through, and so they're not going to come through to next month. Okay, is the is the property insured? Okay, if you don't see an insurance premium at least once a year, that's probably a good question to be asking your property manager. Or if you're the beneficiary, to be asking the trustee, hey, how come I'm not seeing, any, insurance expense or whatever, okay? And that gets to the second point there, which is regular accountings need to be rendered, okay? Now, again, how much detail, how much information you pass along, those are things that'll have to be determined on a case-by-case basis, okay? So it really depends. If the beneficiaries are minors, okay, and you've been appointed as a trustee to look after their best interests, you're probably not going to be reporting to a minor, especially if the minor is a child. Okay, now if the minor is maybe a teenager, and perhaps they're going to take over handling these financial matters in a couple of years. So then at that point, prudence might suggest that you need to start familiarizing them with the various assets of the trust or the estate, and so you might start giving them some basic accounting periodically. Maybe not necessarily every month, but maybe every quarter you sit down with them and kind of go over things so they can start learning about it. Again, all of this needs to be considered. All right, so we have just a few minutes left, and we're going to talk about some best practices to make sure that, to be as sure as you can that you're fulfilling your ethical obligations. First of all, stay organized, okay? Get and stay organized, I should say. So it's not necessarily unusual when you take over administrating a trust or an estate that the records are not in very good shape. Okay, maybe the grantor was handling things and now he's deceased, and he knew all this stuff, so he didn't really keep particularly good records. Well, your first task is going to be to get things organized so you can kind of get your arms around the assets, etc. And then stay organized, stay on top of it. Okay, stay in touch if there's property managers, if there's financial services professionals who are handling various things, insurance and stocks, bonds, whatever. Stay in touch with them. Make sure that you're getting the reports from them that are necessary in order to effectively manage the estate or administrate the estate. Next, communicate. Now, I just mentioned communicating with people who are serving the estate, but also communicate with the beneficiaries. Okay, let them know what's going on. We talked about this earlier, your ethical obligation of confidentiality. Okay, so within the constraints of confidentiality, make sure that you are passing along relevant information to the beneficiaries and or to their duly appointed representatives. Okay, and as part of your communication, be transparent. Okay, if there's something that you don't know, say, I don't know, let me find that out for you. Okay, don't guess or that kind of thing, because if your guess turns out to be wrong, that's almost always worse than saying, I don't know off the top of my head, let me check that and get back to you. Okay, and if you've got some various options in how you handle things and you're not sure which option to take, so perhaps it's appropriate to discuss it with the beneficiaries. So look, these are different ways we can handle this. What do you think about option one? What do you think about option two? Okay, that isn't to say that you necessarily have to do what the beneficiaries say. You're still the person in control. However, being transparent, letting them know what the issues are, can go a long way toward making sure, or not making sure, but raising the probability that they'll be content with your decision. Okay, and finally, and I've mentioned this a few times, get professional advice. Okay. Generally speaking, as the trustee or the administrator or the executor, you're going to be the team captain. Okay, and you're going to have advisors to help you out, probably a lawyer, probably an accountant, maybe a financial advisor, maybe a property manager. You may have other types of advisors and or people who are doing work for the estate. So you're not expected to know every single thing, but you are expected to confer with people when you lack the knowledge or the experience to be making a decision directly. Okay, that's what getting back to that standard of reasonable care. Okay, that's what a professional does. They use reasonable care, prudence, we might say, in making decisions. Okay, so these 4 best practices will help you make sure. I shouldn't use that language, because make sure sounds like never make a mistake. They will give you the best chance of not making an ethical breach. Okay, and boy, that half hour went really fast. So if you have any questions, want to get any help, so these will be in the show notes. You can, and as well as some other links, feel free to email me if it's something personal, if it's a more general question that other people might be interested in knowing about. By all means, post it on social media. By the way, during these shows, I'm right over here, you can't see it, is a chat window that aggregates chat coming from all the various social media platforms that we're streaming to. And so you can always feel free to drop a question or a comment into the chat while the show is going on, and I'll be happy to respond to it. Okay, and then we have the legal stuff. Here we go. There's that Wait a While logo. I'm going to go ahead and close the presentation out. Okay, so that's our show for today. Ethical considerations, they can be somewhat easy to talk about. They're oftentimes much more difficult to execute on, simply because rarely are these issues black and white. Usually we're dealing oftentimes I'll say we're dealing in a gray area. And so, it takes some thought, it takes some consultation with advisors, etc., before you make a decision. So don't feel rushed to decide things. Take your time, be prudent, be ethical. If you're not sure, get some advice, and that way you'll stand the best chance of keeping your practice, your efforts ethical. So that's our show for today. Tomorrow at 10 a.m. Pacific time is Business Lessons from the Military. I hope you'll join us for that. We're going to talk about how you can use U.S. Army or the U.S. Army's organizational plan in your own business. Okay, and you'll probably learn a little bit of military history along the way. And then on Wednesday, also at 10 a.m. Pacific time, I'm going to have my guests, Kelsey and Aaron Holtzman. You may remember Aaron. He was on the show several weeks back talking about being an entrepreneurial accountant. And this week on People Making Money, we're going to talk about entrepreneurship and marriage. Okay, so maybe you're married and you're thinking you want to start your own business or start something entrepreneurial. So I invite you to tune in to hear about the challenges that Aaron and Kelsey faced. And I think they will give you some excellent food for thought. And 7 days from today, then, we'll be back with the next edition of Trusts and Estates Weekly. So thank you very much for joining me. Wishing you a wonderful rest of the day and signing off. Marie, you're my belle. All the best, folks.